Hello and welcome. My name is Paul Grimm. I am a professor of the practice of law and the director of the Bolch Judicial Institute at Duke Law School. And today it is my great pleasure to have an opportunity to have a discussion with two of our professors here at Duke Law School about a recent law review article that has been published in the Duke Law Journal that has the intriguing title of Fact Stripping. Joining me today are Professors Blocher and Garrett from Duke Law School. Professor Garrett, in addition to being a professor of law, is the academic director of the Wilson Center for Science and Justice. And Professor Blocher, in addition to being a professor, is the co-director of the Center for Firearms Law. And it is my great pleasure to talk about this intriguing new law review article that they have come up with. Joe, let me start off with you. Article 3 of the United States Constitution grants to the Supreme Court appellate jurisdiction both as to law and fact, but subject to such exceptions and under such regulations as Congress shall make. Article 1 of the Constitution, of course, empowers the Congress to constitute the inferior federal courts. Your article argues that from these two constitutional provisions, Congress has the authority to enact a statute that could require the Supreme Court justices and the courts of appeal judges to review factual findings from trial courts, whether made by a judge alone or by a jury, with greater deference. You describe such a statute as being a fact-stripping law, and you compare it and contrast it with what I think is the more familiar concept of jurisdiction stripping, which are congressional laws that strip or restrict the ability of federal trial and appellate courts to decide certain issues. Can you explain a bit more for our audience how each of these doctrines operates to limit appellate review?
I'd be happy to, and I really appreciate the nice encapsulation of the thesis of the piece there, Paul. That was really well done, and I think it's an invitation maybe to say a little bit about what motivates the piece by comparing and contrasting jurisdiction stripping and fact stripping. So they both, and I think your comment put this well, they're both efforts by Congress to legislatively respond to perceived problems or deficiencies in the way that federal courts, particularly on appeal, are doing their jobs. And as you said, jurisdiction stripping, about which there are reams and reams of scholarship written, it's something people encounter sometimes even in the first week of constitutional law. There, the move is to take away certain subject matters or types of appeal from the courts. And so the perceived problem, if you like, that Congress is often responding to is disagreement with the way that the courts are coming out on an issue or feeling that the courts are reaching out to decide issues they can't. And so Congress might say, look, you can't do these Guantanamo cases anymore. We're just going to take them away from you, right? So that's one form. People have written a lot about that, raises hard questions about how far can Congress go consistent with the idea of an independent judiciary, which Article 3 also gives us. In this paper, we're focusing on a different issue. If the jurisdiction stripping debate is about subject matters of cases and Congress taking those away from courts, we're motivated by something we see as not having gotten the attention necessarily that the debates over jurisdiction stripping have. And that's what we see as an increasing tendency of appellate courts, and particularly the Supreme Court, to overturn lower court decisions not based on disagreement about the substantive law or even necessarily the application of that law to facts, but the actual fact-finding done by the lower courts. And that's strange, or at least counterintuitive, because we think about trial courts having the primary role when it comes to fact-finding in our legal system. And so when appellate courts do that, they're essentially taking power. I mean, to deny deference on appeal is to move to the appellate courts more authority for fact-finding, and that can be problematic for all kinds of reasons. Number one, that it sort of takes away from trial courts what we think about theirs as their traditional role. So fact stripping, as we see it, is a potential role for Congress to step in, not let the courts of appeal decide for themselves that they have this power, but actually by statute say, no, in some situations or in some ways, you actually may be sort of statutorily required to defer to the facts found by lower court. So it's sort of draws in some ways maybe from the literature on jurisdiction stripping, but the motivation and the function of it would be different.
And I think that point is such a salient point because the jurisprudence that has existed and sort of, and perhaps more in theory than in practice, is that great deference on appellate review would be played to the roles of the district courts, and they will say that in cases where they agree with the outcome of the case, and particularly as it ties in with the right to jury trial that exists as a fundamental right. Professor Garrett, before I have a different sort of question to ask of you, but your thoughts on this first question, did you want to chime in with anything on that?
Well, especially actually, I was going to chime in a bit on exactly the topic that you just mentioned. So you asked Joseph about the structural provisions of the Constitution and how fact stripping is different from the more familiar jurisdiction stripping. I mean, one concern that people understandably have engaged with around jurisdiction stripping is that we want to be sure that, especially where federal rights, where constitutional rights are at stake, there's an adequate federal forum to get a hearing on important constitutional issues. And that's why, you're at Guantanamo, you can't bring a claim in certain courts that raised concerns, and the Supreme Court ultimately resolved many of them over many years. The problem that we're describing has a very different valence and is much less controversial, we think, for this reason, which is that there is an underlying jury trial rights concern. There's a reason why fact-finding is placed in the trial courts and not just with the trial judges. Often it is, obviously, there's a right to a jury. And no judge is supposed to be making ultimate findings of fact in a case. Now, there may be important preliminary findings, like if there's a preliminary injunction entered, where it is the judge making those findings. There are important constitutional protections, and it really, it's been long understood that it's not just a structural problem. It violates jury trial rights if appellate courts are undoing what the fact finder did at the trial level. There are even important concerns, right, with judges making preliminary fact findings where it ultimately will be the jury's job. And there's important law all around that topic, like how do we think about summary judgment? How do we think about taking cases away from a jury? And so that's an incredibly important part of our constitutional structure. Here, in some ways, fact stripping can be a misleading term, although we think it's catchy and captures the idea. But the tools that we were describing involve Congress taking a position that we want facts to be developed by fact finders in a way that's consistent with jury trial rights and promotes individual constitutional rights. We do think that is different than taking things away from the federal courts. Really, this is about placing the facts before a fact finder, which is the familiar place such facts should be. I'd also just step back and say that this is it's just really wonderful to have your perspective on this as a trial judge. Maybe you have a deep trial court bias. I certainly do too, because most of my practice was in federal trial courts bringing constitutional cases before I became an academic. And you mentioned all of our respective centers and interests. Joseph and I look at very different areas of constitutional law, and this is a cross-cutting issue, right? This problem of how do appellate courts review facts, especially in cases raising constitutional claims. It's really a cross-cutting issue that touches on all sorts of different things: review of administrative agency determinations, habeas corpus, regular Section 1983 civil rights cases, which are bread and butter in the federal district courts. And so we're trying to write a cross-cutting paper that raises an issue across a lot of different areas. And we also highlight examples where this is not like a new idea. Congress has done this, and it's been uncontroversial that Congress can. And whether Congress should is a more complicated question. We're not sort of endorsing taking appellate courts or the Supreme Court out of important constitutional cases, but we are endorsing the view that this is a tool that should be thought about carefully, and that the importance of the Supreme Court and the courts of appeals should be focused on law, not on fact development. It never was supposed to be focused on fact development, and to the degree that people have concerns that higher courts are finding facts or cherry picking facts, people are right to be concerned about that, and Congress could be too.
So I think, first of all, I confess my bias as a trial court judge. While I sometimes did not exactly know in a jury trial how the jury got where they got, only in one instance in 26 years of trying jury trials as a federal judge did I ever take away a verdict from a jury, and that was in a civil case where a juror essentially lied during voir dire about having a strong bias against the profession that the defendant was in. And going back and talking to juries, when you're in the system that close to it, you get a reverence for the importance of what the framers had in mind to counteract the abuses of the King of England and his sound-picked judges, and by manipulating areas of law to try the colonial defendants in admiralty courts where there was no jury, because when they were tried in law courts, they were acquitted. And this profound belief that the ordinary members of the public were the ones to be entrusted with deciding what happened is something I think that most of us trial judges treat as reverential. And I want to make sure that our audience appreciates, because I didn't until I was getting into your article and I saw why this is such an important piece. The cases in which you have analyzed this tendency to take fact-finding liberties by appellate court judges and the Supreme Court is not happening in some esoteric issue associated with some issue like the Commerce Clause. It's happening in cases that are defining the scope of constitutional rights, such as the abortion case, voting rights, same-sex marriage, Brady disclosures, race discrimination, affirmative action, and death penalty cases. The kinds of things that most people in this country believe are critically important issues that define what we are. And you point out that the essence of declaring and protecting such important civil rights depends in large degree upon the extent to which the appellate court and the Supreme Court is willing to credit those underlying facts that have been decided through that constitutionally primary way of letting a trial court develop it and a jury decide. You also point out that while generally the law is that great deference will be given to trial court fact findings, and only questions of law are looked at de novo, but that the Supreme Court has, at least recently, in areas such as I have referred to, felt that it was appropriate to give less deference. So what I'd like to do is to help bring this point to the particular instead of the abstract, is give each of you a chance to talk about examples in which this has been done and why it's so important to view this proposal that you have about fact stripping as a way of resetting the compass to where we're back on the right track. And Brandon, if I could ask you if you would go first on this.
I mean, sure. There's so many examples, and we weren't trying to exhaustively, empirically study all the times when, there was a trial record that wasn't referred to. And there are cases where it's ambiguous, where certainly an appellate court or the Supreme Court reinterpreted the Constitution and said that, precedent no longer holds. We're reaching a new understanding of what the Constitution means, and that's a pure decision of law. But often along the way to doing that, they said, look, the reason why we have to depart from precedent is because all the ways in which we think that there was a constitutional violation on these facts. But sometimes, there is an application of existing law and maybe a decision that we're going to depart from the prior test and create a new one, where there's a discussion of the facts that bears no resemblance to the actual factual record in the trial court. We mentioned the glaring example of the Kennedy versus Bremerton case, where the majority opinion says, look, one of the reasons why we need to rethink our Establishment Clause jurisprudence is look what happened in this case, where this football coach was privately expressing religious views, and in dissent, Justice Sotomayor takes the unusual step of including photographs. There was nothing private at all. This coach was doing this, at the 50-yard line. And there were all sorts of questions about to what degree the facts had been properly reviewed or even noted by the majority opinion. And of course, that's not the role of any of the justices to to kind of redo a factual record, but the factual record was so clear in that case. It's fine if the justices want to discuss hypotheticals, but they shouldn't be mixing hypotheticals with the factual record. Without getting into the details, right? There were 2 trials in the affirmative action cases that went to the Supreme Court, and reading those opinions, like one would be forgiven for not realizing that there were trials, that there were trial records in both of those cases. It takes a while reading through those lengthy opinions to realize that when statements are made about our neighbors at UNC and their admissions policies and Harvard and Harvard's admissions policies, and to what degree were they using race, that there are actually detailed factual findings based on a substantial trial record. It's not any of my favoritism to either side in the case to say that the record was objectively quite lopsided. There were just very few witnesses, very little evidence that the plaintiffs had in that case. They largely had 2 experts who largely recanted their own opinions. Like this, the trial did not go well, and the trial record was not good for the plaintiffs. But you would have no idea that those trials even really happened or what happened at those trials in reading Chief Justice Roberts' opinion and many of the other opinions in that case. And that should strike observers as deeply problematic. That's not how we want the Constitution to be developed. If we want to have a system where we have, fact finders, we have jury trial rights, we have important cases vetted based in a common law way, based on facts on the ground, that we want constitutional rulings to reflect certain realities in terms of harms that actual plaintiffs suffer, and to be considering government interests in response. Like, we need to know what actually happened, and we don't want the Supreme Court rendering important constitutional law based on hypothetical scenarios that are quite distant from the factual record. That's the feel that one gets reading these opinions. If one actually reviews the record compiled in these cases, the opinions seem increasingly artificial and removed from the reality of the litigation, and that's something Congress could do something about, and which Congress has done something about in some other contexts in the past.
And Joseph, just as sort of picking up on that and then turning it over to you, I'm struck through my obsession with the rules of evidence is that we make this very important distinction within the rules of evidence between admissibility of evidence and weight to which that evidence is entitled to.
Right.
And particularly with a jury case, the jury is entitled to disregard contrasting evidence and accept what it is. Now, in most instances, the jury is not saying why, unless, as I have done in cases, they're given special interrogatories to answer the specific questions, and they come back and answer them. But that sanctuary of the jury, of being able to say, well, this witness said X, that witness said not X, and then the ruling that they give as liability or guilt or not guilty allows you to infer what evidence they may have been persuaded by. And I think that, as you point out, particularly in some of these cases where the records, factual records, embody days of testimony, carefully screened, where they're not saying there was an evidentiary error on the part of the judge in allowing it to be considered, resulted in detailed findings that make it very hard to go backwards on just simply the appellate record and make assumptions about what should have been given weight and not. And I think that that's concerning. Joseph, would you like to amplify on what Brandon said with his answer?
Yeah, I would. I think the examples that Brandon gave are really perfect illustrations of a particular category of cases in here that are maybe even more striking than the sort of set as a whole, which is those involving what we might call adjudicative facts, right? When we're looking at a case like Kennedy versus Bremerton, right? This is a who, what, where kind of a question. Like, what was happening on the football field when this coach knelt to pray? That is exactly the kind of thing we tend to think is well within the jurisdiction of the, or I would say jurisdiction in the official way, well within the competency and the advantage of the original fact finder to make, and should be entitled to great deference on appeal. So when you have a situation like you have in Kennedy, or you have a situation where you have expert witnesses, as in the affirmative action cases, or marriage equality cases, some other examples that we give in the paper, and still deference is not given, that seems especially, I think, problematic. automatic. Now, there are other cases, which we talk about here, that are a little more complicated. We address in another paper as well, where the court is the Supreme Court, for the first time on appeal, is making major determinations of historical fact in ways that kind of almost declare the content of constitutional rules. And that raises really hard questions, even if they're not the same kind of who, what, where, questions that you might associate with adjudicative fact finding.
So there's even a third category where we discuss cases that have sometimes been nicknamed shadow docket cases, but cases where there was some kind of preliminary emergency relief ordered, where you're not worried about jury trial rights in the same way as the who, what, where regarding a constitutional claim, and in a case that went to trial on the merits. Instead, it was a preliminary fact finding, but there was hearing and factual findings made by a district judge, sometimes quite lengthy, based on serious and prolonged proceedings, even if it is expedited at some emergency relief application. But there it is, the judge's job to make those preliminary findings, and that's the judge that heard the witnesses, had the hearing, and developed those facts. Now, maybe it doesn't raise the same jury trial concerns as adjudicative facts once a claim proceeds on the merits, but if an appellate judge is going to say that this, trial judge was clearly wrong in granting a stay, not granting a stay, whatever it is, there should be some engagement with the factual record, or some determination that the trial judge just got the legal standard wrong, and so all those factual findings and hearings were just not on point. And sometimes you just can't tell because there's just a summary reversal of the trial judge, which just seems like poor appellate or Supreme Court practice, where trial judges do a lot of work and just sort of get slapped for no discernible or understandable reason. But, in the name of efficiency and the like, okay, you can't write a full opinion every time something is decided. But when there are some reasons given and they don't take account of substantial factual findings, that also is deeply concerning and could be a separate topic for Congress. Doesn't raise the same jury trial rights, but still raises the same concern that there was a fact finder in a particular and important context, the context of emergency relief of some type or another, and the factual findings weren't credited or were disregarded. And again, if it's because the trial judge got the law wrong, that's fine. Correct the trial judge's misimpression of the law. But if it's just you don't like the facts, well, appellate courts aren't situated to have their own hearings or make factual findings. They should really be remanding and saying, we're not sure you gave weight to the right facts, but you're the one who knows them, so reconsider.
And I think it's interesting because I think sometimes when you're reading these cases, you are focusing on the posture of the case at the time the appellate or the Supreme Court is looking at it, and you tend to forget just how much of the iceberg is below the waterline. How much has occurred? All the discovery, all the pretrial proceedings, the motions for summary judgment, the motions to dismiss. I was smiling as a trial court judge when I listened to the argument on a recent appeal of one of my cases, where the appellate judge, very candidly came out during oral argument and said, I was just simply overwhelmed with trying to get my arms around the factual record in this case, and a recognition of just how much goes into developing that factual record. But what's interesting is you would think that there's a hard line difference between fact and law, but that is not the case. And so we have pure issues of fact which are supposed to be given the deference that you've been referred to. But then we hear about things, and I think, Joseph, you started to talk about this, legislative fact, the difference between adjudicative fact and legislative fact. And now there's something else that you referred to that I really had not given much thought to before I read your paper, that you refer to as sort of constitutional fact-finding, where the Supreme Court sort of appears to be saying in some of its past cases that, all right, you found these facts and then you made a constitutional ruling. We have an obligation to make sure that the constitutional ruling that you made is consistent with what the substantive outcome should be, and as if somehow that high obligation that the court had justified going back into and perhaps disagreeing with the facts. Could you sort of each speak to me about this sort of slicing? You have mixed questions of law and fact. You've got legislative facts. You've got adjudicative facts. And then you've got these constitutional facts. Are these sort of parsing what is a fact and what is the law, allowing these appellate courts and the Supreme Court the opportunity to go in areas where you would not think it is appropriate to re-examine the facts.
I mean, I guess I'd start by saying what you said at the beginning, Paul, is exactly right. These aren't hermetically sealed categories. They get the lines between them get fuzzier, honestly, the harder you think about them. But as you laid it out, I mean, adjudicative facts are basically the who, what, where, when. Plaintiff was driving a green car, the defendant ran a red light, like those kinds of things. And I think most people are comfortable saying that those are the kinds of things that especially the original fact finder, trial court, judge, jury should have, has comparative advantage in deciding and should be entitled to deference on appeal. As Brandon mentioned earlier, in some of these cases, we're seeing the court not even defer on those, like in a case like Kennedy versus Bremerton. The legislative facts are a much more slippery concept. The name is misleading. I think people who are not familiar may think these are facts found by a legislature. It's not always that way. They're usually used to refer to these sort of more general facts about the world, things that have application beyond the boundaries of a particular case. That complicates the argument for appellate deference because they're not limited to the boundaries of the particular case that a judge or a jury is considering. And so some appellate harmonization, maybe through lack of deference, might be more helpful. I'd just say three quick things on the legislative facts and then turn it over to Brandon. But one thing that we note in the paper is that people sometimes say legislative facts are not entitled to deference on appeal, but that's not always the way it's worked. Sometimes the court does defer even to legislative fact finding by lower courts, and maybe for good reason when you consider that the alternative is the courts of appeals doing their own legislative fact finding, which carries all kinds of problems because they just do it by their own research or picking from amicus briefs, not through the kind of vetting and adversarial testing that you might get as a trial. And if it's fundamentally a comparative question, who do we want to do this, trial or appellate courts, then even if it is hard for trial courts, it may be just as bad or worse for appellate courts. The other is that within the category of I think these mostly fall within the category of legislative facts. And Brandon and I have written about this a little bit in this paper and also in a companion piece. There's a particular category of historical fact that the courts.
The Second Amendment cases. Could you give a little bit of a detail on that, both of you, because I 100%. Think this is a card that has been put on the table and it has not been played out, and the trial courts I think are having a real challenge dealing with this.
100%.
Yeah, just to contrast, so like. Normally, when we think of mixed questions, which just to mention that category, it's like here's a constitutional standard. Was this a reasonable search? You apply that reasonableness standard to the facts surrounding the search, and so that's that standard. It's something that it's typically within the jury's responsibility to apply the law based on how the judge instructed them to the facts in the case. And so, any constitutional claim, you're going to apply the constitutional standard to facts. And how well that was done may itself be sort of a mixed question. Like, did this, what the government did here, did it amount to a First Amendment violation? Did the inadequate performance of the defense lawyer, is that a Strickland versus Washington violation? And often because it's so tied up in do these facts amount to a constitutional violation, often the Supreme Court has said that's sort of mixed in with the law, and so we may review some of that de novo in many situations, but that's different than what we see happening in the Second Amendment, a number of other contexts where it's not here's the constitutional standard, let's apply it to the facts in this case. It's here's some historical facts. We're going to use those to decide what the constitutional standard is. And so we describe this as declarative constitutional facts, like fact-finding is done to declare the content of constitutional rights. We searched long and hard to try to find any example of historical evidence, social science evidence, any such evidence like this being used to construct a constitutional right. And maybe I'm sure there have been like law economists who would have loved for like economics research to cause the justices to say like we interpret the Constitution this way, relying on economics. That has never happened. We could find one arguable example where one part of the three-part Roe framework was developed where the court said we're relying on medical knowledge, but even for the other parts of that framework, the court said we're relying on other general principles, and but that one piece of the Roe trimester framework was said to have relied on medical knowledge, and then 20 years later the medical understanding and research had changed, and the Supreme Court relied on that to say, look, we relied on some medical facts to establish this part of the test. And now, in retrospect, the facts on the ground and the medical research has changed. And so that in some ways that example shows how, when you are relying on facts on the ground to interpret the Constitution, those facts can change. And that may or may not be a good thing. But it was very hard for us to find any examples of this where you're not relying on precedent or other types of reasoning to interpret the Constitution. You're actually relying on fact-finding. This is an uncomfortable and odd role, rarely done in the past, now very common. And the Second Amendment is like you said, is kind of ground zero for the Supreme Court saying, oh, no, we're going to rely on historical facts to decide what the Constitution means.
Joseph, just 1 second. What I'm really fascinated by that is that when the trial court is making factual determinations, there are rules of evidence that guide how that can happen. The adversarial process basically is relied upon by the parties to generate that factual clash. The one exception to that, of course, is judicial notice. And those facts either have to be so notorious, so to speak, in the territorial jurisdiction of the court that everyone knows. So, for example, everyone would know that Asheville is in western North Carolina as opposed to on the coastline. You don't need to call in a geographer to be able to say that. The other one is reliance on sources, the reliability of which cannot reasonably be challenged. And what strikes me about the historical facts premise that underlies the recent Second Amendment jurisprudence is this almost like an assumption that historians have agreed upon the generally accepted facts that are no longer subject to dispute or debate, and so you could almost take judicial notice of that, whereas that has not happened. Historians disagree about interpretations of history as much as lawyers disagree about interpretation of law. And so the standard by which you could measure what you can pick up to rely upon by historical fact, it doesn't strike me that there's any standard there that tells you what you can reach out to. Am I missing something here?
No, I mean, I think one of the things that's fascinating about the Bruin case, which is the one we're discussing here, is both the origin and now the application of this new historical test, right? So Bruin is a case that did not have a trial. This came up to the Supreme Court following on a PI. So there's no factual record in the case whatsoever. And yet we get a 60-page historical exegesis from the majority based on its own historical research and on amicus briefs, none of which, of course, have been subject to adversarial testing or none of which are written by people who've been qualified as experts. It's just the justice is essentially writing an historical essay.
But wait a minute. But didn't the author of the opinion say that, we use normal adversarial testing to develop facts in cases like this?
And that's where the application of it becomes fascinating because then the lower courts are left with the test. And the new test under Bruin, for anybody who's not familiar, is that modern gun laws, their constitutionality must be evaluated based on whether they are, quote, consistent with historical tradition. So don't consider means and scrutiny. Don't consider whether they're effective in saving lives or preventing terror. Are they consistent with historical tradition, right? Now, just as you raised, Paul, send that down to a district court judge who's faced with a flood of cases confronting a constitutional challenge to, say, the federal law prohibiting gun possession by a person subject to a domestic violence restraining order. What do you do? Like, literally, what is your move, right? And some judges, some of these have made the news, have said, do I need expert witnesses? Do I need to get historians in here? Like, are you guys going to bring propose how is this going to proceed?
It's not fair. These trial judges actually have to follow the rules of evidence, and so they can't just say, I'll just take judicial notice that the history and tradition supports this.
Yeah.
They can't do that.
And it's fascinating to me also because, we trust the adversarial system and we trust the trial to be able to have cross-examination bring out the flaws of these adjudicative facts. That's from which an expert who sounds really persuasive, all of a sudden it turns out that they're all opinion and no factual support. But if you don't have that ability, particularly if you're relying upon an amicus brief where by definition there's a biased perspective that amici are not coming in just as sort of friends of the court. They're coming in with an agenda that they want to pronounce. And so they're coming in with what that perspective is. And there's no way of testing or challenging that if it is done on appeal. At least at the trial level, the parties themselves can raise it, or if the judge is not persuaded that they have addressed it properly, can do that, and can do that through certain mechanisms, even if not well used. For example, under Evidence Rule 706, appointing a court expert, or even having some other way of trying to determine what the facts are. I mean, is this as glaring as it seems to me, or am I missing this?
I don't think you're missing it. And right, Joseph, like Brune is not the only case, right? There have been Court of Appeals cases where similarly there was no record below. And they are, for the first time raising on appeal, oh, wait a minute, maybe there's a Second Amendment problem in this case. Maybe we'll make some factual findings.
Mm-hmm. It's truly, and I have to say, just as you were saying there, Paul, one of the things we find fascinating about this, and this really we have more space to play out in the companion piece to this paper, because it ended up, we started writing this paper and we got really interested in this question that you've raised about historical fact-finding and how it works in the sort of originalist frame, and it just grew off into being its own paper.
Well, we have to have a conversation
we really
about
have
that
to
one,
follow
too.
it. It's originalism and historical fact-finding in the Georgetown Law Journal. But one of the things that we struggle with there is this sort of, square peg round hole issue of like a lot of versions of originalism are predicated on a claim that all we're doing here is fact-finding. This is an empirical enterprise. It is objective in the same way that, maybe finding of other kinds of expert facts would be. And yet, the way it's practiced, just as you said, bears no resemblance to how we do other forms of fact-finding. No adversarial testing, right? Doesn't happen at trial. You don't have expert witnesses. There's no deference on appeal. It's something else. And so I think either originalism has to give up on saying this is fact-bound, or we need to really consider putting trial courts back in the driver's seat to at least do some of the fact-finding. And yet, for all the reasons we just said, that's really hard. A trial court can't necessarily make these findings. And you've mentioned this before, Paul, but I just reiterate, too, that in some ways it's asking of history as a discipline something it can't provide. Historians aren't in the business of like settling, the sort of debate. Did the framers think you could disarm dangerous people? Is not the kind of question that a historian is going to say yes or no with no explanation. That's a hard, ongoing discussion. That's not their job.
One example that we give is, and it's one that I know well because I was, a long time, I teach habeas corpus. I was teaching habeas corpus at around the time that the Guantanamo cases were of great interest. And it was really sheer sort of historical accident that my good friend Paul Holliday, a legal historian, had been spending more than 10 years in the King's and Queen's Bench archives, opening these parchment rolls that no one had opened before. And because he was interested in equity and lots of other related questions, it wasn't substantive interest in habeas. He certainly had no interest in ever being an expert on Guantanamo or what U.S. courts could do. This was an effort as a legal historian to understand what the King's and Queen's Bench were doing in these equitable cases, and they happened to be habeas petitions. And all of a sudden, this case goes to the Supreme Court in Boumediene, where the justices really need evidence. Like what? At common law, like what was the scope? Who were the types of people who could bring habeas petitions? And the reported cases were very limited. The historical record, the claims made by treatise writers and the like, were based on a handful of cases that really didn't reflect the practice. No one had looked at the parchment rolls, translated them. Even Paul Holliday, it took 10 years. It was only like he was doing a random sampling. He wasn't reading every single one. No one could humanly do that in their lifetime. And so the historical record was exceedingly inadequate. But for the first time, we actually had all this evidence that he had dug up that, habeas petitions were being heard by all kinds of people, which totally belied any modern conception of citizen or not. Like that wasn't the way that the courts thought about it then. It was sort of, were you subject to the crown or not? And all sorts of people who were trying to argue that they had rights, aliens and enemies, people who were enslaved, were all bringing habeas petitions, and that evidence was really powerful to the majority opinion in that case. But there's no way that if a district judge had said, "Can you do some history for me because we have these tough habeas questions coming up," it wouldn't be possible on a litigation timeline.
And I want to finish because we're nearly at the end of this. We could go on for hours. This is so fascinating to me. But what might assume from what the Congress took that up? And they came up with a statute that did set some standards for fact-finding. What do you think the reaction might be from the courts to that? They have shown an ability to be very ingenious if they wanted to sort of escape the deferential application of facts by the various doctrines that we've talked about. And what might the reaction be? What do you think might happen? I'd be interested in each of your perspectives briefly before we close this out.
I can give a brief one. I mean, one of the things that we discuss in the paper is that a tool the courts have if they want to resist the kind of statute that we're contemplating, or if they want to generate the kinds of questions that would not require deference on appeal, is to craft constitutional doctrines that are going to result in a lot of mixed questions of law and fact. Like as Brandon sort of mentioned these earlier, right? If you have a constitutional test that is multi-factor and fact-intensive, it's going to just almost inevitably throw out a lot of mixed questions, which in turn arguably increases the need for independent appellate review. And we actually give an example in the paper, which may so be memorable for people, which comes from obscenity doctrine. So obscenity, not protected by the freedom of speech. The court has struggled for decades with how to identify it, and in an early case called Jacobellis, they made this basically a mixed question, and the result was a lot of fact-based appellate review, which included, notoriously, the justices and their clerks gathering to view pornographic movies to decide whether they were or were not obscene. Now, that is obviously not how the justices want to or should use their time. So in a later case called Miller, they adopted a new, different, and less fact-bound approach, which is still the current test, about whether the average person applying contemporary community standards think it appeals to the prurient interest, whether its depiction of sex is patently offensive, and whether the work considered as a whole lacks all literary, political, social, political value, whatever. That new test requires less of a mixed. It generates fewer mixed questions, therefore less need for appeal. But the point being, the doctrine itself is one of the tools that can justify more searching appellate review.
Well, I think that the story of that doctrine also illustrates how sometimes the Supreme Court has learned this lesson many, many times, and maybe we'll need to learn it many more times again, which is that to adopt fact-intensive standards, even if it is a mixed question, even if it is like in some sense allowed for higher courts to dig into the facts, it places higher courts in an uncomfortable position. It actually gives more discretion to lower courts because all of a sudden they have to do something extra fact intensive. It still raises jury trial rights questions if you have a trial judge doing something more fact intensive, which could require the trial judge to take something away from the jury. There are all sorts of problems. There are some attractions to having brighter line tests that are more grounded in law than fact. I will say that in some contexts the Supreme Court has gone above and beyond to try to police statutes where Congress has said we shouldn't be reconsidering the factual record. Now, they have done that mostly in habeas corpus, where there were other values, federalism. We don't want to be digging into the factual record assembled by state courts. We want people to be bringing out facts, litigating facts in prisoner litigation in state court, not in federal court. The Supreme Court has gone, arguably above and beyond what Congress really sought in very restrictive legislation, but the Supreme Court was very much aligned with Congress. Congress itself was sort of incorporating some Supreme Court-made doctrine, trying to cut back on factual, evidentiary hearings in the district courts. It is sort of a piece with not wanting district judges to be doing a lot of fact finding, not wanting a lot of evidentiary hearings. But that the politics and the alignment is different. But that is a context where Congress said we want strong deference on factual questions, even where constitutional claims are involved. And the Supreme Court said yes, deference plus, we like it. So this can happen, and this is something that we certainly have a Supreme Court which is very attentive to the text of legislation. Congress can be very clear. There are examples of very clear, very specific legislation speaking to factual deference. And we aren't trying to provide a roadmap on how or when Congress should do this. We do tend to think that if Congress does this, you shouldn't be targeting certain types of constitutional claims or litigants. There are reasons in the jurisdiction stripping literature why we should just be worried about Congress trying to place a thumb on the scale in favor or against certain types of constitutional rights. I mean, that's a reason why people like me have concerns about some of the restrictive legislation around habeas corpus. We shouldn't be treating some types of constitutional litigants differently. But in general, the idea that we want to make sure that there's a strong and robust factual record in the trial court before appellate courts take their swing at it, that's something Congress can absolutely help to safeguard.